I'd like to put a pause on this conversation and invite Emily Chang from the ACLU to join us. Thank you very much for agreeing. This was something that Eileen specifically had asked to have a little more information on the First Amendment. We have the written materials, but we really appreciate your being here to present this afternoon.
Well, thank you so much. I'm going to assume this is a fresh cup of water. Right?
I'm not sure you should assume that.
You know what they say about
since
assume.
you hadn't arrived yet, I don't think that's a fair assumption. So we shall, I believe that is a used cup of water.
Glad I said something.
I
thank
believe
you.
Maybe someone, I know Paul went out to get you some, but there's a picture right there.
It's fine. I don't plan for speaking for that long.
All right. Well, I'd like Paul to be in the room when you're speaking. So here he comes. Thank you, Paul.
Thank you.
Oh, this one's filtered. All right.
Thanks so much. Well, thank you to the entire work group for hosting me here this afternoon, and especially to Chief Justice Fairhurst for accommodating my child's field trip schedule. I greatly appreciate it. So my name is Emily Chang. I'm the legal director at the ACLU of Washington, and the ACLU was asked to provide comments regarding whether the U.S. Supreme Court's recently decided case in Janus requires dissolution of WSBA or, you okay? Or transfer of its functions to the Washington State Supreme Court. So coincidentally, I was a law professor for 6 years. I did happen to teach First Amendment law at the University of Utah Law School, so I had some familiarity with the issue. I'm not going to spend a lot of time reiterating what was already in my letter in the hopes that I will leave time for questions. I will also hope that the things I do say are so persuasive you won't have a lot of questions. We'll see. I also want to underscore at the outset, this is the disclaimer section of my comments, that I'm not going to delve into the policy considerations. There are obviously many that you all are confronting, but I'm just going to focus on the First Amendment. So the single biggest takeaway I have to offer you is that the First Amendment does not actually require you to change anything about the existing structure of the State Bar Association. You may wish to do so for other reasons, but it's certainly not required by the law. And I also want to be sure that you take away that if your stated reason for adjusting the structure of the Bar Association is to make it easier for members not to spend money on ideological speech that they disagree with, transferring functions of the bar to the state Supreme Court is actually going to make it harder for members to object to ideological speech. So, first, Janus doesn't mean that you have to dissolve the state bar. Janus actually has no impact at all on the state bar. And second, transferring functions to the state Supreme Court would actually make it harder for people, your constituents, the bar members, to complain about their money being used to support things that they don't agree with. So I'm going to address each of those in turn, and feel free to interrupt me if you have questions. On the first point about Janus, so as I stated in my letter, Janus just doesn't apply in this context. Keller does, and Keller is still good law. So I didn't say this in my letter, but I want to point out that the U.S. Supreme Court consists currently entirely of lawyers. They're all lawyers. They were all, at some point in their lives, members of one bar or another, and they get it. They may not appreciate public unions, but they sure do appreciate what it means to pay bar dues. And you can quibble with licensing fees. Yes, licensing fees. And you can quibble with, the court's ability to extend its empathetic understanding to this constituency or that constituency. But one thing that's fairly clear if you look at their cases over time is they are really sympathetic to what it means to be a practicing lawyer, because that's just where they all came from. So the court's deeper understanding of the legal profession, it's actually often reflected in the case law. And one of the classic examples is it treats the attorney-client relationship differently, that's LSC v. Velasquez, than it does the doctor-patient relationship in a very similar situation, and that's Rust v. Sullivan. It can sometimes be frustrating that this is the case. I'm sure many doctors out there wish that there were more practicing doctors on the U.S. Supreme Court. But what it means for lawyers is that the justices have broadcast loud and clear their continued support of mandatory licensing fees. And the key piece is that they fully embrace the government interest behind those fees. And I quoted from that old case in my letter. I won't re-quote it. But a huge part of the government interest is actually in regulating a profession that the public doesn't have a huge understanding of, is not necessarily sophisticated enough to regulate itself, and to improve access and quality for the public that lawyers serve. So I'll also just note that as a practical matter, there just aren't the votes to extend Janus to this particular situation. And as a legal matter, Keller remains binding unless and until the court itself says it doesn't. So none of this means that the Constitution requires a state to have mandatory licensing fees, but it clearly doesn't prohibit them. So the second point I want to make is that if you want to protect against paying for ideological speech that you disagree with, you should continue to work with Keller. You may have problems with Keller. I'm sure a lot of people have problems with Keller. The Keller deduction may not be set perfectly, but the distinction laid out in Keller between chargeable non-ideological activities and non-chargeable ideological activities remains both workable and the single best way to ensure members are not forced to pay for ideological speech that they disagree with. I understand that there's been some conversation about line drawing, additional line drawing that Janus may require. And I want to be clear about something. Janus does not require you to redraw any lines, because Janus says, in the context of public sector unions, there can be no line drawing at all. One of the core premises of Janus is that the line drawing just does not work in that particular context. So the lines that you need to draw are still the same lines that Keller required you to draw. And Keller assumes, like the basic fundamental premise of Keller, is that the Bar Association will sometimes say stuff that some people disagree with, and that some of the stuff it says will be ideological in nature. Keller takes that as a given, and it tries to distinguish between that which the bar can charge its members for and that which the bar cannot. Running bar fees, or licensing fees, through the state legislature or through the state Supreme Court does not actually provide increased First Amendment protection against compelled speech to dissenting bar members. It reduces that protection. Because expenditure of such fees via a branch of government would be considered government speech, and because one largely, and this is just a general, well-settled matter, it's part of being a member of the United States of America, you largely cannot object to monies that the government spends on its own speech, you would actually be making it harder for people to object. So, of course, the state Supreme Court, it would be well within its discretion to continue the tradition of having something akin to the Keller deduction, but it would not be required by the Constitution to do so, whereas if you keep the existing WSBA structure, the Constitution actually requires that WSBA continue to distinguish between chargeable and non-chargeable fees, ideological and non-ideological speech that it can charge its members for. I hope that was helpful, and I'm happy to take questions.
Any questions for Emily? Whoops, lost my pen. Eileen.
Well, what they left open in Keller were two things. If you have a line of cases on what's the scope of regulatory, which I think there's probably pretty good agreement on, it's the improvement of the legal profession part that Keller itself acknowledges is, I think, the extreme ends of the spectrum are clear. It's that middle ground that's a problem. And if, other than Fleck, there are decisions talking about where that mushy ground is, that would be helpful. And the other is Keller clearly leaves open the association issue, which was also discussed in Janus. And as that relates to ideological speech, if you're aware of any cases that deal with that aspect, because association obviously is not dealt with, not resolved just by reducing bar license fees.
Yeah, so I'll deal with the first question first, which is the mushy ground and the line drawing problem that you have. And I want to say at the outset that I'm not here to give you guidance on that mushy middle ground. That's not my area of expertise. It's not something that I've done a lot of research in. I don't envy your job in trying to ferret out what falls on the right or the not chargeable side of the line. My main observation is it's actually the same pile of mush that you had yesterday, the day before, 10 years before Janice, and so on, that it's actually still the same situation that Keller presented state bar associations with. I think, what the court said in Janice was, look, we tried the mushy line drawing in the context of public unions, and it didn't make sense because all public sector union speech is inherently political. But it was also very careful to say that that's just not the case for state bar associations. And so I think the message is it may be hard work. I mean, both hard and work. It's going to be hard work. But you got to do it. And that's just kind of, what the Constitution requires, that sometimes it is messy. Sometimes you're going to get it wrong. Sometimes a member's going to sue you and they'll lose that suit. And other times a member's going to sue you and they're going to win that suit. And it is through that kind of process of divination that you find your way to the line, right? And that's, frankly, the best I can give you. And I hope it's not too disappointing. On the association issue, I'd have to give it some more thought, but I think that what the court is saying, and look, the line between speech and association is itself not incredibly clear, right? The court, I do not think you should read the court's language in Keller as saying, we're leaving this door open, you should come on in. I think you should read the court's language in Keller as saying, we don't need to reach the association issue. Our job is to decide these cases on the narrowest grounds appropriate, and we don't have to get there, right? For better or worse, the court has been actually fairly direct in its signaling. I don't think you can even say it's signaling at a certain point. At a certain point, they're just telling people, bring us the case, we're going to overrule Abood, right? And it didn't work out the first time around because of the untimely death of Justice Scalia, but then they got their ninth justice, and they were able to bring the case to completion. This is a court that was specifically interested in public sector union speech. If it were interested in this other issue, if it believed it to be pressing, you can bet your bottom dollar that it's going to tell you that. It has not been shy about saying, and now we want to get to this other thing. So I don't know that fully answers your question. I will say my understanding of the doctrine is you don't have an association problem here. And I'd be happy to present you with additional, I could go back and write you another comment. But I don't think the court is interested in reaching that issue. And I think that it would be a weird thing indeed if you all were to say, well, in anticipation of this decision that may or may not come down 5 to 10 years from now when the court gets to it, we're going to do this very radical thing that would actually also at the same time undercut member First Amendment rights.
Any other questions? Mark, please.
May I make a comment?
You may make a comment.
I thought the association question was decided in 1961, Lathrop versus Donahue. They said, and so that has never been.
Thank you for that reminder. I forgot about Lathrop.
Well, it was many years before you were born. I, however, was around, and no. So it was, and so that's 1961. Nobody's ever questioned that since then. And the plaintiff in Janice was not a member of the union. That's why there was no association issue on the plate. So, there are vast differences, and I really appreciate your comments today. I think you're spot on.
Oh, and actually, so thank you for the reminder. And it's ironic because I think I actually quote Lathrop in my letter. But the other thing that I wanted to flag is the nature of the government interest in compelling association with a state bar is actually far different from the government interest in compelling association with a union. And this does actually bring us full circle back to Lathrop, which talks about the nature of the government interest. Yeah, WSBA serves its members, but the entity that it really serves to protect is the public, which, if you have people who aren't actively governed by WSBA's regulatory and disciplinary structure, there's a real government interest in making sure that legally unsophisticated lay people, people without law degrees, don't get taken advantage of. And that's very different, and I think the court would inevitably find, and has found it, significantly compelling.
Yes, Esperanza.
I was hesitant to ask you. I'm not an attorney. I'm the public representative on this group.
Thank you for your service.
Well, thank you for giving such a very clear-cut presentation. I like it. So, access to justice, the work for access to justice in any bar, in any state, I think will always be viewed, the details of how to get there and what needs to be done can be viewed as ideological, right? So, and I have a problem with that because it's ideology that got us to this place to begin with. It's an ideology that created a system that is unfair and imbalanced. And so, and it's ideology that sustains that system. But when you bring up access to justice, it becomes ideological. So with all that you've laid out and all that I've heard here, with Keller and Janice and Lathrop, and I've read more case studies than I ever thought I would, but, and I'm not going to say I understand all of it, and I appreciate people that have taken the time, some people around this circle and some people in the room that have taken the time to help explain these things to me. How do we actually get to access to justice in this climate?
I don't know that that's a question that my answer should be binding on. I can certainly offer you, my opinion, the ACLU's opinion, and also I want to offer you my condolences in being surrounded by so many lawyers for such a long time.
I can hold my own. I've been doing this for a long time, so they're good people.
I don't know if, so Mr. Swiggle is also raising his hand. I don't know if I
Right,
should
well, I'd
address.
like you to answer Esperanza, and then I'll go to Paul next.
Okay. So, I think that is a decision for WSBA, the members of the work group, whoever else is involved in setting the Keller deduction and determining what falls on which side of the line. As a policy matter, I would say that I would remind you to go back to the heart of the issue, which is what is the government interest in having a bar association in the first place? And it is to protect and ensure access to quality representation equitably, right, across populations. That there shouldn't be populations in the state, particularly vulnerable and marginalized populations, who either do not have access to legal services at all. That would be a disservice. It is not in the government's interest to do so, and neither should there be populations that are at higher or increased unnecessary risk of receiving inadequate or subpar representation. I think that's the core of the matter, which is and this does actually go back to the First Amendment test. If strict scrutiny applies and you have the government interest at issue, the restrictions on the speech need to be narrowly tailored, or the least restrictive way of, I'm trying to translate this into English, but it's just not English. Okay, so it has to be the least restrictive way possible for WSBA to accomplish the government interest. So the question is, are you actually serving the government interest when you engage in these other activities? And is the way that you were doing so narrowly tailored? Was there a better way that you could do it that didn't implicate compelled speech? Was there a less restrictive way that you could have done it? And I think those are the questions that inform, and this goes back to Ms. Farley's question, that shouldn't, the very large, big picture questions that drive how you kind of make your way through the pile of mush in the middle.
Paul?
Excellent answer, thank you. Esperanza, I guess, from my perspective, and I don't really consider myself to be a constitutional expert, but when I think about access to justice, I think about very foundational constitutional principles of equality under the law. And so access to justice is a little bit like Miranda rights. It's a little bit, it's a little bit more like constitutional underpinnings of what the legal system is, and how the legal system is supposed to operate. And so I don't see access to justice as like political speech or political association. I see it as the administration of justice. It's just very foundational. So I've never had any concerns or, qualms about the Bar Association championing and being involved in finding solutions to access to justice issues, and I never hear from members that they share that concern, that they view that as political speech or political association. Never heard it.
I think the other thing for me to point out is that however you draw the line, part of what's baked into Keller is that some people are always going to disagree with you, and part of the lesson of Keller is it's sort of the price of doing business, right? This is what it means to be a state bar association engaged in this type of work. I think Keller accepts, baked into its foundational premises, that there is going to be disagreement and dissent. And, I don't think we would want to live in a country where there wasn't. But that the bar continues to serve a valuable purpose, and that's why it should be continued to permit to collect these fees.
Not seeing any other hands. Kyle or Jane on the phone? Okay, was there one? Doug, did you have one?
Nothing from Kyle.
Okay, none from Kyle. Go ahead, Doug. Doug is the head of the discipline section here. Department.
Now he's standing behind me.
Only because he has. Only because he has to.
I have three questions. They're fairly narrow questions. Would you prefer that I ask them seriatim, or do you want them all? Okay. My first question is it your analysis in looking at Janus that the Supreme Court found there was no compelling governmental interest in state-imposed agency fee arrangements? Second question. The question is whether the presenter's analysis of Janus is that the United States Supreme Court found there was no compelling governmental interest in state-imposed agency fee arrangements in the union context. My second question is, if the integrated bar issue was to come before the United States Supreme Court again, either through a second grant of cert in Fleck against Wetch or otherwise, would you agree that the court, if it was to uphold Keller, would have to find an alternate justification for the holding in Keller other than the Abood justification? And third, if you know, of course, all of the United States Supreme Court justices are lawyers, but do you know how many of them practiced, when they did practice, in integrated bar states versus agency regulatory states?
I'll answer your third question first, because it's easy. I don't know. I have no idea. Sorry, here, let me swivel so I'm not speaking with my back to you. So your first question was whether Janus held that there was no compelling government interest in agency fee arrangements. So, sort of. What Janus holds is that in the public sector union context, which is a key distinction, actually, because they obsess over like the nature of unions and how political they are and how there's budgetary impacts for the things that they're advocating for. You know, if you're not careful, a union could drive a government into bankruptcy, which I really sincerely hope is not the case with WSBA. Like, come on, that was funny. So, and that in the context of public sector unions, the two particular government interests articulated in Abood were not compelling. You know, I suppose they may have left a very small, I won't even call it a door or window, it's like a peephole, that if someone were to come up with a separate, independent government interest that had not previously been articulated in Abood in favor of public sector unions and was able to show that collecting the mandatory agency fees in that context was narrowly tailored to meet that new articulated government interest, maybe the outcome would be different. I'm skeptical, but, you know, if we're going to read Janus narrowly, that's how I would read it. And even if we wanted to read it more expansively, I think it would still be limited to the public union sector context. Your second question was, if the question of an integrated bar came to the U.S. Supreme Court, would it need to distinguish Keller and come up with basically new compelling government interests? And I would say no, it wouldn't have to, because the interests articulated in Keller are actually wholly different from the interests articulated in Abood. Abood is about public sector unions and the need to prevent free ridership, the need to have a single entity with which the government can negotiate union contracts. And the interest at issue in state bars has nothing to do with that, right? It has to do with protecting the public from lawyers who may engage in abusive practices, who may not be up on their CLE credits. I mean, the lawyers that maybe you see in the context of bar discipline. The government interest has to do with a fairly sophisticated profession regulating itself, because lay people may not be as well equipped to regulate lawyers. And it has to do with ensuring equitable access to the services that lawyers provide. And really none of those interests transfer easily into the union context. So I don't think the court, I would be really surprised if the court granted cert to one of these cases, because, and I think actually what they were trying to signal, and again, this is the court is very straightforward, right? It's telling you what it wants. And what it's telling you in Harris is, don't bother bringing us these cases. We plan to overrule Abood. We are gonna do it, right? Like, that's what Justice Alito is saying very clearly in Harris. I wanna do it. As soon as I have the appropriate vehicle, bring me the appropriate vehicle. Abood will be overruled. Don't bother us with these state bar cases because we think they are different.
Great. Thank you very much. We really appreciate your time and your being here.
Thanks for having me, and good luck.
Thank you.